Good morning. I hereby call to order this second meeting of the Pennsylvania Public Utility Commission for the year 2019 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. As always, we want to note our safety instructions on the inside of our agenda in case we need to leave the room. On our first matter of this morning's agenda is the approval of the minutes for December 20th, 2018, and I call on Commissioner Place, who is the editor.
Thank you. I've reviewed the minutes of the December 20th, 2018 public meeting and move that they be approved as submitted.
You have heard the motion by Commissioner Place. Is there a second?
Second.
Second by Vice Chairman Sweet. Is there any discussion, further edits? Hearing none, all those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 5-0. At this time, we'll call upon our Secretary, Rosemary Chiavetta, to lead us through today's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1. It is recommended by Director Monahan and the Bureau of Audits that the Commission adopt in an omnibus motion both audit reports appearing on page 1.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
There's a motion by Commissioner Place. There's a multitude of seconds. I think the loudest one that I heard was Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2, in matters presented by Director Sophie and the Office of Special Assistance, it is recommended that the Commission adopt the proposed opinion and order in the application of PennDOT.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second? Second. Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Yes, I have a motion on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my motion be placed into the record as if I had read it in its entirety. Before the Commission today for consideration and disposition is the petition for extension of time filed by Norfolk Southern Railway Company regarding work to be performed in the above captioned proceeding. Norfolk Southern indicates that the necessary alteration of the crossing has not been completed because of other priorities, specifically those associated with the federally mandated positive train control deadlines. The Pennsylvania Department of Transportation filed an answer to the petition opposing the requested one-year extension, as the work was to be performed by December 31st, 2018, as outlined in the Commission's secretarial letter dated October 20th, 2015. I agree with PennDOT that Norfolk Southern needs to complete the necessary alteration, including the installation of new warning devices to this particular at-grade crossing in Mercer County as soon as possible. As the Commission stated in 2015, this work is necessary and proper for the service, accommodation, convenience, and safety of the public. Although the plans for the work to be performed at the crossing did not receive Commission approval until June 2018, Norfolk Southern continued to be aware of its obligations to complete the project by the end of 2018. I believe that Norfolk Southern's resources should be utilized to complete the necessary alteration to the crossing rather than engaging in additional litigation in this matter. Therefore, I move that the petition for extension of time filed by Norfolk Southern Railway Company at this docket is granted in part. 2, the deadline for Norfolk Southern Railway Company to complete the necessary alteration to the crossing by the installation of new warning devices where Connolly Boulevard crosses at grade the single track of Norfolk Southern Railway Company in the city of Sharon, Mercer County, be extended to no later than September 1, 2019, or as soon as possible, as requested by Pennsylvania Department of Transportation. And 3, the Office of Special Assistance prepare an order and opinion consistent with this motion. Thank you.
You have heard the motion of Commissioner Place. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, is there any objection to taking the previous roll call? Seeing no objection, the matter as amended passes 5-0.
It is recommended that the commission adopt the proposed opinion and order in the informal investigation regarding the PECO Energy Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion?
Madam Chair, I have a brief comment.
Vice Chairman Sweet.
Thank you. At our December 20th, 2018 public meeting, we adopted an order allowing for comments to a joint settlement entered into by the Commission's Bureau of Investigation and Enforcement and PECO Energy Company regarding an investigation into the wrongful termination of multiple low-income customers during the winter moratorium in the winter of 2016. As part of the settlement, PECO agreed to pay a civil penalty of $10,000 and to increase the amount available for matching contributions in its Matching Energy Assistance Fund, MEAF. The low-income advocates in their comments on the settlement, to which they were not a party, expressed the opinion that PECO should simply increase its hardship fund by $20,000 and not require that the funds be matched before they're available. The low-income advocates expressed concern that there would be excessive delay because of the matching requirement. PECO responds by explaining that its MEAF is a matching program and there's no separate MEAF budget or mechanism to provide direct contributions to local community-based organizations or other recipients. In that context, PECO says that the comments and suggestions of the low-income advocates would be a material change to the settlement and is not acceptable. They, in effect, do not want to turn this into a direct contribution. While I will not vote to unravel a settlement negotiated by the parties, I believe that PECO can act independently to publish the availability of the money and to encourage others to contribute to the fund so that the full amount that is anticipated will be spent to aid low-income customers in an expeditious way. I strongly encourage PECO to be creative and flexible, to not be muscle-bound by their own documents, which set forth the rules for the MEAF, and that, again, they be creative, not obstinate, and find a practical way to fulfill the spirit of the settlement commitment, this commitment for the $20,000 forthwith. Thank you very much.
Thank you, Vice Chairman Sweet. Is there any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended in an omnibus motion that the commission adopt the last item on page 2, the complaint of Bernice Wallace versus the PECO Energy Company, and continue to include both items on page 3 and the first item on the top of page 4, ending with the complaint of Dimitro Bova versus the Philadelphia Gas Works.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Continuing on page 4, it is recommended that the commission adopt the proposed opinion and order in the tariff supplement proposed by the Pennsylvania American Water Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second? I will second it. So moved by Vice Chairman Sweet and second by myself. Any discussion on the motion?
Madam Chairman, I have a statement and ask that it be placed in the record as if I had read it in its entirety. What's at issue here is what's called in the parlance contribution in aid of construction. There is an understanding that at certain points in time, new customers should be required to provide a capital contribution in order to obtain service, and it is calculated on the basis of distance and cost, comparison of revenues. What PA American is asking today is that the tax effect of that, which has newly come about because of the recent job and Tax Cuts and Jobs Act of 2017, is now taxable. So what PA American has asked is that they be allowed and their customers absorb the income tax effect on that contribution. So in other words, under the gross up method, the $1 million contribution that a new customer would be required to make would then be increased by the effective statutory income tax rate of 21%. So the customer would now have to pay $1.21 million in order to make a $1 million contribution to the company in order to obtain service, instead of simply paying the $1 million contribution in aid. So by way of background, the job cuts and jobs that, sorry, I keep messing this up. The Tax Cuts and Jobs Act of 2017 has made significant changes to the income tax rate, and we have flowed through almost $400 million in tax reductions to customers and $52 million within the context of just the water industry alone. It was not a totally favorable outcome because what it did do is change the application of income tax to the contribution in aid of construction. I agree with PAWC that with the proposed no gross up method, an example given previously, the customer would pay the $1 million to get the facilities extension, which then becomes a credit to the rate base, so it's at no cost to the customers, but that the other customers, through the life of the asset, pay for the cost of the income taxes. I think granting PA American's petition in this circumstance is appropriate for several reasons. First off, the tax responsibility is that of the utility, not the developer. The taxes are paid under the utility's income tax return, not the new customers. Just like we flowed through the effects of the tax reductions, we should flow through to customers the imposed costs of the Tax Act. Furthermore, I believe that grossing up the CAIC for the statutory tax rate is potentially overcharges the customer already contributing contribution aid of construction. The effective tax rate of utility is oftentimes lower than the statutory rate due to the allowed deductions under the federal tax code. And using the statutory tax rate potentially overcharges the customer and creates a windfall for existing customers. I also think this outcome treats all utilities fairly. For the gas and electric companies, they do not follow the gross up method. They charge the $1 million and then flow through, as PAWC proposes, over the life of the asset, the income tax effect of that contribution. I don't see any valid reason on the record of this case, nor can I think of one that would justify discriminating among utilities. The argument over whether the natural gas distribution industry is more competitive than the water industry or creates greater economic impacts than the water industry is mostly rhetorical in this case, and I really don't find it helpful to reaching an outcome. The fact of the matter is, in the Commission's 1988 docket, when this issue first arose, the energy industry asked for no gross up, and the water industry said we want a gross up. A presumption now, 30-plus years later, that we should go back to that old methodology, and that should be applied by default, I also don't find that compelling or appropriate. There are other concerns that are specific to the water industry. For example, investor-owned companies are in competition with municipal entities as well as municipal authorities that don't pay taxes. So the issue doesn't arise as to them. So I think it puts to require the gross up method puts the privately owned water companies at a disadvantage relative to their growth strategies as compared to their competitors, the authorities. It's also instructive to note that our sister regulatory agency to the north, the New York Public Service Commission, did exactly what PA American is asking that we do today, reverse a 30-year-old precedent and permit the water industry to not gross up the contribution aid of construction now. We should be doing the same thing as was done in New York. So based on the foregoing, I disagree with the ALJ's determination. I believe that PAWC has met its burden of proving that it should be used in no gross up method. And because of this, I would vote to grant their exceptions to the recommended decision and will be voting no on this matter. Thank you, Madam Chairman.
Thank you, Commissioner Kennard. Any further discussion?
Just Just a brief comment, Madam
Vice
Chair,
Chairman Sweet.
and I apologize, I did not prepare a lengthy, thorough, complete analysis of this for the record, but perhaps we'll do so in a subsequent proceeding when and if we have one. Just a couple of quick reactions to the Commissioner's, quite frankly, well-reasoned and logical argument. One is, it's a well-reasoned and logical argument, but one that none of our staff, professional staff, nor the administrative law judge agreed with, given the record that was before them. And because there are several settlement agreements in place with other water companies that would piggyback on our ruling today, we would in effect be reversing a 30-year precedent on a fairly thin record and making it apply industry-wide. I'm hesitant to do that based on this record. I certainly have an open mind as far as the future and the impact on these matters. And in fact, next week at NARUC, I will attend a panel which will be discussing this very topic. It is somewhat arcane. I would also note that the recent Tax Reform Act provided hundreds of millions of dollars worth of benefit to customers in Pennsylvania because of the actions of this commission in implementing that new federal law. But there were offsets in that law, and it wasn't completely a question of utilities getting a tax break. There were some instances, this one being among them, where the matter may tilt in the other direction. Final note, the commissioner very, I think, adroitly referred to customers. The point should be made that the customer we're talking about is a developer. It's a customer. The consequences of making this shift will be spread upon customers, the other ratepayers of the utility, when and if this would occur, because the benefit would be rolled into the rate base of the utility. So I'm sorry for that sort of stream of consciousness reaction, Madam Chair, but I did want to get on the record that this is still a work in progress. I don't think because something's existed 30 years, it has to continue. But on the other hand, I'm hesitant to reverse that precedent without more thorough analysis, and I'm hesitant to do it in the face of an administrative law judge's decision based upon a record that was before that judge and upon the advice of our experts and our staff here. Thank you very much.
Thank you.
Madam Chairman, if Commissioner
Bernard.
Sweet is signaling that there's further work we can do on this to advance the discussion of the issue, I'd be more than willing to do that and look forward to working with you to find that forum.
That would be great. Our two offices will work together to see if we can develop an industry-wide inquiry on this subject, because I agree with you. I'm not completely persuaded, but at least my interest is piqued by the fact that the electric and the gas industries have a different situation. And I'm delighted that you're starting to look to New York for precedent, because I will be bringing before you some suggestions that will be have been adopted in the great state of New York, who sometimes has a different philosophical approach than all of us in Pennsylvania. Thank you.
Any,
Madam Chair,
Commissioner Coleman.
I want to commend Commissioner Knott for a very compelling, persuasive argument here this morning, and therefore I will be associating myself with his statement and will be a dissenter.
Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 3-2, noting the dissent of Commissioner Kennard and Commissioner Coleman.
Turning to page 5 and matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended in an omnibus motion that the Commission adopt all of the items on page 5, beginning with the application of Sanford Energy, and continuing to include all of the items on page 6 and all of the items on page 7, noting that the third item on page 7, the security certificate of PPL, has been postponed to the public meeting of February 28, 2019. And finally, continuing on page 8, the omnibus motion to include and end with the single item on page 8, the security certificate of Pike County Light and Power Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 9 and matters presented by Chief Counsel Panque and the Law Bureau, it is recommended in an omnibus motion that the Commission adopt both items on page 9 regarding the UGI utilities.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second? Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? Motion passes 5-0.
Turning to page 10 and matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt ALJ Dunderdale's recommended decision in the complaint filed by Center Township.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, it should be noted that both of the last two items on page 10 have been postponed to the public meeting of February 28, 2019. Turning to page 11, it is recommended that the Commission adopt ALJ Hoyer's and ALJ Johnson's recommended decision in the rate case of the Pittsburgh Water and Sewer Authority.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
Madam Chairman, I have a statement of an administrative nature. This is This is an all parties. I have a motion, I'm sorry.
Yeah.
And I asked that the motion be placed on the record as if I had read it in its entirety. This is an all parties, all issues settlement that we are adopting here today, and I'm very pleased that we're being able to do so and move the authority to the next leg of the journey that we are taking with them. And in the next leg is the compliance filing. The ALJ recommended decision has several changes to the tariff which fall into two camps. One is typographical, administrative. Another one have issues of substance. To move this forward, PWSA has adopted and agreed to adopt the typographical administrative changes with no objection from the parties. In order to move this matter forward, my motion would push the specific tariff issues that may be controversial over to the compliance filing, so we can adopt the rates, get those into place, and keep this authority moving forward in our inquiry as well. So therefore, I move that the joint petition be adopted in full, the typographical clarification and language modifications be incorporated into the compliance tariff, that the Office of Administrative Law Judge prepare an opinion order consistent with this motion as it was written.
You have heard the motion of Commissioner Kennard. Is there a second? Second by Commissioner Coleman. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, there's any further discussion? And is there any objection to taking the previous roll call? Seeing no objection, the matter as amended passes 5-0.
It is recommended that the Commission adopt ALJ Johnson's initial decision regarding the complaint of Jacqueline Ruskey versus the Pennsylvania Electric Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion?
Madam Chair, I have a motion in this matter.
Vice Chairman Sweet.
I ask that my motion be placed on the record as if I'd read it in its entirety. Before the Commission is the initial decision of Administrative Law Judge Conrad A. Johnson, which grants a payment arrangement on the portion of a customer's arrearage which accrued outside of the customer's participation in a customer assistance program, and denies a payment arrangement on that portion of the arrearage that accrued while the customer was on cap. This initial decision grants the payment arrangement in error as it violates the Public Utility Code. This case centers on the legal characterization of the informal decisions rendered by the Commission's Bureau of Consumer Services, BCS. In this instance, Ms. Ruskey obtained a payment arrangement from BCS and appealed it by filing a formal complaint. The formal complaint was the subject of a certificate of satisfaction, which ended the formal complaint document, but did not alter the BCS informal decision. She made no payments on this payment arrangement, instead filing another informal complaint with BCS. This time, BCS dismissed the informal complaint because Ruskey had been issued a prior Commission payment arrangement, which she did not satisfy, and she then filed a formal complaint as on appeal of that BCS decision. Ruskey did not comply with the original payment arrangement. The filing of a formal complaint does not nullify the underlying payment arrangement. It stays the BCS decision pending the outcome of the formal proceeding. Here, the formal proceeding ended with the Commission order that accepted the certificate of satisfaction as ending the appeal. With the discontinuance of that appeal, the BCS informal decision became final. Therefore, Ms. Ruskey is not eligible for a second payment arrangement. In addition, the initial decision mischaracterizes the appeal process, and my motion spells out in detail, painful detail, how one should determine whether an appeal from a BCS informal decision is final. Therefore, I move that, number one, the initial decision of Administrative Law Judge Conrad A. Johnson is reversed, consistent with this motion. Secondly, that the Office of Special Assistance prepare an appropriate order consistent with this motion. And that's it.
Is there a motion you've heard the motion of Vice Chairman Sweet. Is there a second on his motion?
Second.
Second by Commissioner Place. Any discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. On the matter as amended, any further discussion? If there's no objection, we'll take the previous roll call. Hearing none, the matter as amended passes 5-0.
Madam Chairman, that completes the regular agenda. Turning now to the carry-in agenda. On page 1 of the carry-in, it is recommended by Executive Director Freeman that the Commission adopt the proposed order approving the appointments to the Damage Prevention Committee.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And turning to page 2 of the carry-in, it should be noted this item has been withdrawn by the Office of Special Assistance. Madam Chairman and Commissioners, that concludes all agenda items for consideration today.
Thank you very much. Before we close out, I do want to acknowledge February as being Black History Month and want to invite all of you to attend the Commonwealth's multi-agency celebration. It will be held next Thursday, February 14th, from 12 noon to 1 p.m. in the Forum Auditorium here in Harrisburg. The pre-program entertainment will begin around 11:30 a.m. The theme for this year's Black History Month celebration is Black Migration, and it will emphasize the movement of people of African descent to new destinations and subsequently to new social realities. This year's program will feature Pennsylvania African-American historian Jeff Kirkland as the guest speaker. The York YWCS Temple Guard Drill Team will also be performing along with the Earth Tones and musician Antoine Cameron. And light refreshments will follow in the auditorium of this building. So we please hope that you attend next week. And if there's nothing else to come before us, is there a motion to adjourn?
So moved.
Is there a second? Second. Motion by Commissioner Kennard, second by Vice Chairman Sweet. All those in favor of adjourning, say aye.
Aye.
Any opposed? We are adjourned.